Mr. Nordsrom, he received notice that the lawsuit, Mr. Johnson's lawsuit, was going to be filed and served on Wednesday. And it was filed. I'm not sure if it was filed on Wednesday or exactly when it was filed. It was filed, and then a hearing was scheduled on Monday. Now, Mr. Nordsrom indicates that he gave Mr. Norman a call on Saturday, and he got notice of this emergency hearing, which was yesterday morning. Now, under the rules of court, under Rule 4.03E, which many of the county board members, the commissioners are probably already aware of, for civil action to be started in the county court, upon a municipal or other public corporation by delivering a copy to the chair of the county board or the county auditor of a defendant county. So then Mr. Norman called, and he said, I haven't been served. Apparently a copy was delivered to Mr. Nordsrom, which was then eventually delivered to Mr. Norman, but here the law says that a copy must be delivered to the chair of the county board or the county auditor. So Mr. Norman said, well, I haven't been properly served, so the court's jurisdiction has not been invoked. And so it's in this capacity that I represent Mr. Norman yesterday, and really indirectly the board, in the sense that the court didn't have jurisdiction over the case because Mr. Johnson and the attorney had not followed this procedure. And that is almost a courtesy but a legal requirement, that is to deliver a copy to the chair of the board or to the county auditor. So at the hearing yesterday, Mr. Nordsrom objected to me representing Mr. Norman in his official capacity with respect to this right. And I said, well, he in his official capacity, if you're not going to make the argument, Mr. Nordsrom, I'm going to with respect to lack of public service, personal service. And so what happened was that Mr. Johnson's attorney spoke, and Mr. Nordsrom spoke, and then I was the only one to raise the defense on behalf of the county board that there wasn't proper service. And the judge said, you know, basically, you're right, there wasn't proper service, and so the court doesn't have jurisdiction over the case. So when you have something so important as a lawsuit by the county administrator against the county involving the county board, nothing should be botched. Everything should be done carefully. In fact, Mr. Hall, you were very particular about, and Mr. Welby, about the agenda, about each of these little procedures. I think they are important. In fact, that's what I'm most concerned about in my practice, is getting these procedures right. And so I believe that the reason I'm a proposed retainer and fee agreement, it's the next item, is that we need to ensure that the county is represented in the lawsuit that Mr. Johnson has brought. And in all matters relating to that. Mr. Johnson has expressed his desire to continue the litigation, and I'm sure he will, and he has already started it. And so what I'm proposing is a retainer and fee agreement that would cover representing the county in the civil lawsuit that Mr. Johnson has started. Right now the court doesn't have jurisdiction unless service has occurred since the hearing yesterday. But I view it as a very important matter for the county to consider having special counsel. Yesterday it was necessary. Mr. Nordsrom did not argue that personal service was defective. I argued personal service was defective, and the judge agreed that personal service was defective. And so this is the reason why we need civil counsel for that lawsuit.